Welcome to the Appellate Division, First Department. We have almost 6 hours of argument time requested and some multi-party cases. So I'd ask that you only request the time that you need, not the time that you want. If we have further questions, we will keep asking them. And we are familiar with the briefs and the records. People versus Ceda, submitted. Ruiz versus La Permusic. Okay, you did not request any argument time, then normally we don't give time if you don't request it.
No, that was an error.
Do you wish to submit yours and then we'll just take it under submission?
If I could have 3 minutes?
I'll give you each 2 minutes. I mean, we are familiar with it and you didn't request the argument time, so, but I'll give you each 2 minutes. Sonoya is submitted. Chiu versus Chin, appellant. Respondent? I'll give you 6 and 1 and 6. Hangan versus Edgewater Park. EPAA. 5 minutes.
Respondent, Appellate landscaping request 5 minutes.
Okay. Well, you don't have a cross appeal. That's funny, because none of the appellants requested rebuttal time, and you requested rebuttal time. But I'll put, okay. So 5, 5, 2, and 5. People versus Simmons is submitted. Second Child versus Edge Auto, appellant.
Appellate, 10 and 2.
Respondent? Okay, I'll give you 7, 1, and 3. 244 Madison versus Utica, appellant.
Respondent, 5.
5 and 5. Wacht versus Stern, appellant.
Thank you, Your Honors. Appellant, 7 and 3 for rebuttal, if I can.
Respondent?
Respondent request 5, Your Honor.
5, 1, and 5.
Thank you.
Daquin, appellant. Respondent? Submitted. Talken Capital versus Omanoff, appellant.
Yes, Your Honor, we request 8 and 2.
Respondent?
8 minutes, Your Honor.
8, 1, and 8. Tibs versus Jalongi America, appellant. Is the respondent here on this matter? Do you wish to argue or do you wish to submit? I'll give you 3 minutes since they are not here. Gurev versus Lakul, appellant. Respondent? 6, 2, and 5. Vargas versus 622. I know this is also a multi-party case.
Your Honor, for J.T. Megan, respondent appellant, I request 6 minutes and 2.
I'm sorry, who are you representing?
J.T. Megan, respondent appellant.
Okay, J.K. Flooring,
I am, Your Honor. J.K. Florent request 5 and 1.
622 third,
They submitted.
they submitted. And AFR? 5, 1, 5, 1, and 5. People versus Dominguez? What? Did you put in papers on that? Wasn't it all cross indemnification issues? Okay, you put in papers and requested time? What? Yeah, but your arguments aren't they covered by other parties? I don't recall all of you asking for papers. asking for time, what? Okay, 2 and 2. People versus Dominguez?
Yes, appellant requests 8 and 2. Respondent requests 5.
5, 1, and 5. And JJCRR is submitted. Okay, the first case on for argument is Ruiz.
May it please the court. I represent plaintiff appellant Kathy Ruiz. Your Honor, Your Honors, the court misconstrued the law, misconstrued the standard on what is the standard for whether a statement is of and concerning a plaintiff in a defamation case. The court held that the statement at issue here was not of and concerning plaintiff because, quote, a reasonable reader would not have understood that the post was about her.
Wasn't her name even in the post? I mean, her name and her, I think her email address or website
Yes.
was in the post itself?
Yes, Your Honor. Her name and a link to her website.
And the
Was in the
comments
post.
specifically referred to her.
They did indeed, yes. And these were all issues that were briefed by below substantially. There's an argument here that this wasn't raised below. I mean, in fact,
It's
respondent
the heart
did-
of what the court held, though, so obviously we're allowed to address it since it was the basis for the court's
That's right.
decision below.
That's right, Your Honor.
Whether or
And
not you raised it, the court adopted that reasoning.
yes, that's correct. Reasonable reader is not the standard, to be clear, of whether a statement is often concerning a plaintiff. The standard is the reading public should be acquainted with the parties and the subject, and if that reading public understands that statement to have been about the plaintiff, then that is of and concerning. So the standard is not reasonable reader, it's reading public acquainted with the parties and the subject. This was Carlucci v. Poughkeepsie Newspapers Court of Appeals case, and this own court reaffirmed this in Three Amigos as JL Restaurant v. CBS News, where the court said that the plaintiff bears the burden of pleading that the defamatory statement designates the plaintiff in such a way as to let those who knew him understand that he was the person meant.
Thank you.
Thank you, Your Honor.
Daniel Zalkowitz and Associates, PC, for the respondent, may it please the court. I obviously heard the line of questioning directed towards appellant. We take the position that just because a name is included in a post does not necessarily mean it's of and concerning.
You have people emailing her or texting her, and one of them specifically says, on April 26th, I'm sure you've seen it, but some rogue guy put you on blast on LinkedIn, and it's trending over Reddit and Fishbowl advertising circles. So that person that read the statement that was put out realized that it referred to her.
Correct, Your Honor, but the question is if one person out of all these other people in these comments that were submitted, and again, these
So you know that
comments,
there was more than one comment.
but they were not referencing Ms. Ruiz, they were not saying you should be doing this, it was talking more generally about this is actually an issue within the advertising company. Now what advertising industry, what our point was in the appeal is that this was never raised, these comments were never submitted to actually show as of and concerning her. It was, again, more generally talking about the harm of the industry, so we did not actually focus in our paper.
So you're saying that this was simply a question that he was asking her, what should I do now, Kathy, what should I do?
So, I mean, if you were to put it, it can be read like that. Again, I believe just because one person would the general public read it the same way. One thing that was not addressed at the lower court, which unfortunately will become an issue, is the anti-SLAPP component of this. We did submit a letter requesting the court to further brief it. This is a public statement on a LinkedIn profile about a public issue. It was not considered in the motion to dismiss because
That's not part of the appeal. We can only consider.
it's not because we were not aggrieved
we
from the
can't
decision.
consider that issue unless it comes back to us.
No, unfortunately, there's a chance it may be here for a
May
third
come back.
time. But
We often get cases back. It won't be the first time.
exactly. I mean, again, we stand by the point. I think it can be read what should I do, Kathy Ruiz? It's not saying you are the one that did this. If he was to put my name in this post or any of our names in this post, I don't think anyone would believe necessarily that they were talking about me. But
Why did he refer to her site then?
so again, but there's actually nothing to indicate within the documents that this is readily available, the soundofideas.com. This could be anybody's site. And in fact, when you look at her pleading, she actually said the site's locked. So anyone looking at this site would not have had to be able to say this is Ms. Ruiz's site.
Thank you.
Thank you.
Very much. Hangan versus Edgewater Park.
You,
What?
you skipped,
Did I skip one?
yes. You versus Chiu.
Oh, I'm sorry, wrong case. I called the wrong case. Chiu versus Chin. Sorry, I didn't mean to skip you.
Good afternoon, Your Honors. May it please the Court, my name is Elizabeth Friedman, and I am appearing for the defendant's appellants in this matter. Your Honor, the Supreme Court erred in denying defendant's motion for summary judgment. There was no evidence here that raised any factual issues to preclude summary judgment because the unrefuted evidence here established that Police Officer Chin did not act recklessly as a matter of law. Neither Supreme Court nor the plaintiff has raised material triable factual issues.
I wasn't clear. Did he testify definitively that he put on sirens and lights? I know that didn't have to do that, but is that what he
He
testified?
actually did testify to that, Your Honor, that he did engage the sirens and lights when he moved, when he crossed the double yellow line and moved to travel west into the eastbound lane. He saw that the lane was perfectly open. He did testify that he engaged his lights and sirens, and the police accident report that's also in the record did also state that his
And
lights and
I
sirens
don't
were
recall,
activated.
did the plaintiff state definitively whether she saw lights or sirens?
The plaintiff testified that she didn't see the police vehicle before she was hit. She did say that she didn't hear any
She
lights
didn't
or
look
sirens.
that way, she looked the
She
other
looked the
way.
wrong way. She looked the other way in the direction of traffic. She didn't look both ways before she crossed the street. She was crossing outside of the crosswalk in the middle of the block. She darted out between two stopped vehicles that were stopped in the traffic lane heading west, and she didn't look both ways. Now, there are other dangers to that. There could be other obstructions. There could be bicyclists. There could be anything. So if you cross in the middle of the block, outside of the crosswalk, really, you should be looking both ways.
Is the fact that the officer said that he thought that the vehicle may flip if he averted in a certain way raise a question of fact as to how fast he was going?
No, Your Honor, and I'll tell you why. That was a judgment call on the basis of the police officer. He did testify that he braked as hard as he could when he saw the plaintiff come out just less than a car length away. He had no time. He did testify that he thought about veering, but he thought it would flip the van. He thought it was too late, it would flip the van. So he took the evasive measure that he could, and he braked as hard as he could. Anything beyond that, the momentary lapse is not evidence of recklessness there. He didn't have time to take the evasive measure that he would have liked to take. And in fact, Your Honor, Vehicle and Traffic Law 1104 is designed to preclude this type of second guessing. In the heat of the moment, when they're responding to an emergency operation, they're responding to an assault with a weapon in the vicinity of Madison Square Garden. He is exercising due care for safety. That is borne out by the fact that he was able to avoid two other pedestrians while he was changing lanes to go into the other lane, and he also was able to avoid a car that pulled over to let him pass.
How far from the intersection was he?
I believe it was 500 feet from the intersection, about 500 feet. And he testified that he was only going in the eastbound lane from the westbound lane 300 to 400 feet. He also proceeded from a dead stop. So when you're accelerating from a dead stop, it seems that he couldn't estimate his speed, but he could not have been speeding. The evidence shows that he was going at a very modest rate of speed at that point. He only went 300 to 400 feet from a dead stop. So how fast could he have been going? Unfortunately, the accident occurred because the plaintiff precipitously darted out into the traffic lane, and he could not avoid the accident as he tried. And there's no evidence here of reckless disregard for safety, which is a standard, and it's a very high standard. And here, there's no issue of fact. The plaintiff didn't fail to refute all the evidence showing that, in fact, this officer operated his vehicle with due regard for the safety of others under the circumstances. I'd also like to just refer this court to two cases that we cite in our briefs, Green versus Zarella and Chiu versus City of New York, in which the police car did, in fact, cross the double yellow line. In both cases, this court reversed the denial of summary judgment and granted summary judgment to the defendants. This case is not distinguishable in any material respect from those cases. And for that reason, this order denying summary judgment should be reversed. Thank you.
Thank you very much.
Good afternoon, Your Honors, and may it please the court, Monica Becker for the respondent, Mrs. Chiu.
So what's the factual issue as to recklessness?
Sure. So the factual issue really here centers around the fact that immediately prior to striking the plaintiff, he avoided two other pedestrians,
Right, but
putting
they were in
him.
a crosswalk, and this was.
They were not in a crosswalk. They
Well,
also.
Why did the fact that he avoided two pedestrians mean that he was reckless in hitting this one? It's a different situation, a different timing. What does one have to do with the other?
I don't think it was a different situation or different timing. They were also crossing, as Ms. Chiu was, from between the stopped cars in traffic that he pulled into the
Right, but you
oncoming
need,
lanes of
the
traffic.
recklessness standard is a very high standard, and you need something other than he missed two others and he hit her, so that means he was reckless. You need some evidence that would support a finding
Yes.
that it was inappropriate for him to be, it was an emergency operation, or he was acting inappropriate under the circumstances, something
So it
that
was.
would show recklessness.
Sorry, Your Honor. It was inappropriate for him to continue driving in the lane closest to the traffic. He was in that lane, swerved into the other lane to avoid those other two pedestrians, and then went back into the lane closest to the traffic, knowing that it was likely that another pedestrian could enter from that lane. And he also, there's absolutely no evidence as to his speed here whatsoever. The idea that he was
Right,
driving
but
at a
wouldn't you have to show, first of all, they're allowed to speed if they're in an emergency operation, but wouldn't you have the burden to show some evidence of recklessness, that there was speeding or something that was outside the parameters of what was
I
allowed?
think that there is a question of fact as to the recklessness of his speed, as evidenced by the fact that he was not even able to swerve to avoid her. The idea that he was driving at a moderate speed because he had started from a dead stop doesn't apply, because he had already been driving for at least a block to a block and a half before this accident occurred with Ms. Chiu. There's no evidence that after he almost hit two pedestrians, he slowed his speed in any way. In fact, if we're speculating as to his speed, as it seems that defense wants to,
We don't want to speculate as to.
that he might have increased his speed based on the fact that he was able to swerve to avoid the other two pedestrians and then wasn't able to swerve to avoid Ms. Chiu. He also testified that he was not wearing his seatbelt, which obviously may have countered.
That's not required, though, is it? If it's a police officer?
Well, it obviously goes to his thoughts or intentions, in fact, of avoiding the accident, because
Radio call pertained to an assault in progress with a weapon, am I right?
that is what the Sprint report shows.
Is it your position that the fact that the officer was driving counter traffic is per se indicia of recklessness?
Not counter to traffic, but the fact that he encountered two pedestrians coming out from between the parked cars, or I'm sorry, traffic, prior to encountering this plaintiff, and didn't then at the very least remain in the other lane, which would have increased his visibility and ability to avoid other pedestrians crossing from between those cars, is reckless. He also testified himself that the protocol of the department is to activate the 4 different types of sirens. He only activated one. He also personally
required
believed
to sound his siren at all, or is that one of the exemptions that's granted to him as an officer?
I don't necessarily think, well, the law doesn't necessarily say that he needs to activate lights and sirens, or that
I'm sorry, does it say it or not?
I'm sorry?
The law, does it require
The
him
law
to
does not
sound?
require him to, or rather, it doesn't say that if he doesn't, that it is reckless. But if you're taking in a factual determination of everything in its totality, I think the fact that he remained in that right lane, if you will, instead of the left lane where he could have avoided the other two pedestrians, coupled with a question of fact as to his speed, coupled with his failure to use all 4 sirens as he said is required by the department protocol. He also testified himself that he believed that the sirens together with the rumbler, which he could activate using the horn, was the best indication of an approaching vehicle to pedestrians, yet he failed to use that, again, even after avoiding these other 2 pedestrians, knowing that there could be other pedestrians. It's all of these factors coupled together that equal the question of fact as to recklessness, right? So this court also in Handelsman versus Lewin did say that reckless disregard is a fact-specific inquiry. And I think the facts here...
Given that I wrote that decision, it was a very different, fact pattern in that case. I mean, I saw you mentioned that in your brief, but that was, somebody going 80 to 100 miles an hour in a very residential area. And it is very fact-specific. So.
Understandable, but it just highlights how fact-specific and distinguishable this case is from other cases cited by defendants. And just because defendant mentioned, I believe it was the Green case, if I'm not misremembering, in that case, the court's decision doesn't highlight or mention any factors regarding speed or previous indications of an accident that happened almost immediately preceding the accident that would have indicated to the officer to take a different action or to take other evasive or precautionary measures in order to avoid something. I understand that the policy is for officers not to have to second guess themselves while in the course of responding to an accident, but that doesn't mean that you can willy-nilly cause other injuries while attempting to do so.
Thank you.
Thank you.
Just very briefly, Your Honors, all of the purported factual issues that plaintiff tries to raise here, they're not material here, they're not germane, and in addition, they are based on sheer speculation. That is not sufficient to raise a factual issue here. So number one, the issue of the lights and sirens, even assuming that Officer Chin did not have his lights and sirens activated, this court and the Court of Appeals have repeatedly held that that is not evidence of recklessness. In fact, Vehicle and Traffic Law 1104C specifically exempts authorized emergency vehicles that are operated as police vehicles from activating their lights and sirens. So even assuming they were not activated, that is not evidence of recklessness here. Also, plaintiff points to sheer speculation as to which lane Officer Chin should have been traveling in. Sheer speculation. What makes one lane more or less dangerous than the other lane in the the 2 eastbound lanes, and whether or not he was wearing a seatbelt? Nothing relates to whether or not that's a material factual issue as to the officer's recklessness here. The fact that he was able to avoid the 2 pedestrians and the car, that's actually evidence that he was exercising due regard for safety. That actually supports the city's motion for summary judgment. Thank you very much.
Now we're calling Hangan versus Edgewater. Somebody wants to argue? We could all just sit here for a while.
Good afternoon, Your Honor. C. Briggs Johnson for the appellant, the appellant respondent, Di Bartolo Landscaping. 2 issues with regards to us.
You're okay.
Yes, I am Di
didn't want to
Bartolo.
be called an
I'm
Go
Irish,
ahead.
but I'm representing Di Bartolo.
Right.
It's a bad joke, sorry. So the question is, did we launch an instrument of harm under Espinal? Did we completely displace EPIC's duty to safely maintain the premises? Number 1, did we create the hole? No. We mowed the lawns, we blowed leaves, that was it. That's what the record shows. We didn't create the hole. We didn't make the hole any more dangerous, right? That's what the church case tells us from the Court of Appeals.
So you have the prima facie burden,
Absolutely.
and the person who testified didn't have any specific knowledge as to what happened on that particular day and what landscaping services performed right before the incident. So how did you satisfy that prima facie burden to show that the actions of the landscape company didn't either create or exacerbate the condition?
Great question. So I think we have to talk about maybe the alleged defect, right? If we're talking about a hole, like an actual puncture into the ground, I'm mowing lawns.
But there's also an argument that it was covered up in a way that made it invisible.
Yeah, but that,
So it's broader than just that.
right, but if I'm covering it up, right, that means I have to affirmatively do something. I have to exasperate a dangerous condition. If I'm not cutting that area of the lawn because Epic's telling me not to cut that area
How
of the
do we
lawn.
know that if there's no one with personal knowledge about what was done before the event?
Well, I think Di Bartolo's principal said that when he goes to the premises once a week, right, and he sees what the landscaping's going on, he knows from his history there since 2015, right, we're talking 5, 6, 7 years, I don't touch that area that much because it's not a prime area. The grassy area where they had the Olympic event, whatever you want to call it, the Labor Day Olympic event, that's the prime area. That's the area they generally cut.
Didn't Mr. Di Bartolo testify that the field was an afterthought that was simply cut and blown, not rather that it was never mowed?
Well, I'm sorry, repeat that question?
Mr. Di Bartolo, at record 973,
Okay.
said that the field in issue was an afterthought. It was simply cut and blown. And he went on to say, if the workers saw a hole, they wouldn't contact anyone from Edgewater what is it?
Epic.
They
The owner.
Yes, sorry, my P looks like a D.
That's okay. My handwriting's miserable too.
Oh, mine
Well, not that yours is miserable, mine's certainly miserable. But I think that goes to the point of creation and exacerbation, right? Let's say that we did think that side of the field was an afterthought. That doesn't mean that we created the hole, right? That just means that we didn't really pay that much attention to that side, because that's not what the owner wanted.
Mr. Ponce, who was the general manager of Epoch, said that if there was a problem, if when cutting the grass, Di Bartolo saw something, they would fill it up with topsoil, and they would otherwise notify him.
Right, but that goes back to the other part of that's not our obligation, right? They're the landowner. They're the ones that are responsible for safely maintaining the premises.
Is there a question as to whether Di Bartolo launched an instrument or force of harm here?
If we fail to report a hole that we didn't create?
The hole in question by one, let's see, I'm trying to see who testified here. The plaintiff said it was 1 foot by 3 inches deep, and the architect for plaintiff, when he measured, found it 2.5 feet by 2.5 inches. So you're saying that if there was a hole of that nature, that size, no duty to report?
No, because we don't own the property. It's not. Epic has admitted that it's their responsibility to safely maintain the whole premises. So unless we completely displace their duty under Espinal, completely displace the duty to safely maintain the premises, we're not liable as a subcontractor. That's what Espinal says, and that's what Church says, at least in my opinion. So unless there's any further questions, I'll rest on my brief.
Thank you very much.
Thank you.
Now, since we're not going in order, who are you here for?
I am here plaintiff, respondent, appellant.
What's the name of that plaintiff? Oh, you're the plaintiff, I'm sorry.
Yeah, Jennifer Hangan. And I am David Sasser from Kellner and Kellner. May it please the court. The lower court did err in granting Di Bartolo's summary judgment upon re-argument because Di Bartolo did not carry its prima facie burden. It did not establish, it did not launch a force or instrument of harm, and it did not establish.
Well, tell me how they did. How did they launch?
So they launched a force, so if they had met their prima facie burden, they launched a force or instrument of harm by their pattern and practice of mowing around defects in the subject field, which they definitely did mow, but it was an afterthought. And by mowing around the defects, they allowed the grass and the vegetation within the defect to continue growing while the grass outside gets trimmed, and then it creates the false impression that there's level or even ground there when there's actually a camouflage defect, and that's exactly what happened here. And the camouflage defect, in addition to it being dark at the time of the accident, made it more dangerous than it would have been had DiBartolo simply just not mowed that land at all. That's not what happened.
So you're saying that it's not as if we have 12 weeds, is that the area that they failed to, well, the defect, was sort of like a mirage. It was covered as if it was one level area, when in fact there was a hole there.
Correct.
Because they when they mowed the lawn, they made it appear as if there was it was all level.
Yes, exactly, because it was a 2.5 or 3 inch deep hole that they admittedly mowed around, and that would cause it to look level. And the expert testified when he inspected it, was partially concealed by vegetation, and it gives the false impression that there isn't a defect there. When it is, that makes it more dangerous than they found it, and at least a question of fact based on that, whether they launched a force or instrument of harm.
Your counsel says that there was no duty to notify Epoch. What do you say?
Well, so the Epoch testified to the contrary, and the contract here is much more extensive than DiBartolo made out, and it did include that they were supposed to make recommendations for good things to do with the subject field, essentially, and that if they had damaged anything, that they were responsible for repairing it on the subject field as well. So I believe they would have had to notify them, which they also failed to do. But that really, we're going back to the launching the force or instrument of harm. By their admitted practice, they said over and over again, no one cared about this area. It was an afterthought. We just mowed any defect. We just went around it. This is all separate and apart from the fact that they didn't carry their prima facie burden because they only have general testimony as to what they did that day. So really, it never should get to that part of, did they launch a force of harm? Did they not? It was their initial duty to prove they did not launch a force of harm, which they failed to do. I'd like to switch to EPAA now, if I can, with my time remaining. That's the the Edgewater Park Athletic Association. They're the ones that managed the event, paid for the event, supervised the event, and the court below is correct to deny their motion for summary judgment because they owed a dual duty to plaintiff. They owed a duty under the common law because they controlled the event, and they also owed a duty under their lease with the owner, which permitted them to run that event and then also required them to take the premises and keep them in good repair. For the event itself, the issue there is there wasn't sufficient lighting. The event organizer had control to install $20 lanterns from Home Depot to make so people could see. As part of this closest to the pin event, they spray painted a tee box on the field with spray paint that would wash away in a week or two. They could have spray painted around the defects to warn of them. They could have put...
There were some amenities provided by EPAA, right?
Yes, an additional, so this was a week-long event, and throughout the event, they installed porta potties, which they directed where to place them. They had concession stands. They got a stage from the city to come hold the award ceremony at the end, and nowhere in their papers do they deny that they had this level of control over the event.
Do we know what
I was going.
Do we know at what time the event ended?
So plaintiff testified that it ended around 7:45 and the accident happened at 8 p.m. There's a clear question of fact. I believe the EPA says it ended around 6:30, but there was no scheduled endpoint. And it's the sort of thing where the event isn't over with the last swing of a golf club, just like if you're at a baseball game at Yankee Stadium, it's not over with the last out. So the precise time it ended is a question of fact, but she was still there after, within 10, 15 minutes of it ending, talking to her friends, deciding what to do next, and that's when she stands up and steps into the hole.
Thank you.
Good afternoon. May it please the court. My name is Colleen Sorensen, and I represent the defendant appellant Edgewater Park Athletic Association. The trial court erroneously denied the association's motion for summary judgment. This court should reverse because the association had no duty to maintain the field.
Did they have a duty to bring lighting in, knowing the time that this event would be ending? It would most likely be a little dark?
No, for two reasons. First, the undisputed evidence is the lighting did not cause the plaintiff's injury. She testified that
Isn't that part of her claim, though, that she couldn't see the hole because of the overall conditions, including the lighting?
In the complaint, but at her deposition, she testified that she could see 3 to 4 feet in front of her and that she could see the ground. Her expert also opined that the hole was not visible even in light, so the light could not have made a difference in her fall.
Do you think that issue should be decided as a matter of law in a summary judgment motion?
I do, yes. But I wanted to start with the lease, if that's okay. Both the lease and the common law neither imposes a duty on the association to maintain the field. The lease does contain a maintenance obligation. However, that obligation contained in paragraph 25 of the lease at page 280 of the record extends only to the premises. If you look directly above that at the heading of the
You're talking about the
record.
indemnification issue now or about the primary liability?
No, I'm talking about the lease and the obligation in the lease.
No, I know, but are you talking about the indemnification claim by the owner of the property, or are you talking about the plaintiff's liability?
Plaintiff's liability claim.
I just want to clarify what you're discussing.
Oh, sure. Yeah. So the trial court found an issue of fact with regard to whether the lease imposed an obligation on the association to maintain the property or the field. And
Wouldn't that come from the fact that they were given permission to have this event at the property, which obviously the event was not in the actual lease premises, it was in the field, and they were given permission to operate that event in the field?
there are two potential sources argued. We don't think either is. One is the lease and one is the control over the event. It's our position when there is a pre-existing defect in a premises that the relevant question is whether you have control over the premises, not over the
Didn't they
event.
have a license to use the premises on that day?
They did have a license to use the field.
So wouldn't that create some duty on their part based on the license to create a safe environment?
Yes, with regard to the event, it wouldn't, that wouldn't apply to pre-existing structural defects in the ground, though. It would apply to the way the event was run, and it was not.
But isn't part of having a safe event or having responsibility for the event a safe egress and ingress to and from the event?
Well, we think it was safe because the lighting was not the cause of her fall. And additionally, there's not a real dispute about when the event ended, because Mrs. Hangan testified that she fell at 8, that the event ended at 7:45, but she was forced to concede that you can't really golf in the dark. So the golfing wasn't happening in the dark. What was going on?
But what about the analogy made to the Yankee Stadium that the event doesn't end the second it events? People loiter around, they talk, they have to leave. It's not the golfing ends and people are out the door a second later necessarily.
Sure, I think that's
Especially because there were many other things. There were concession stands, there were.
There were not. At this event, there were
Okay,
no
well,
concession stands,
you
there was
don't
no
leave
porta potty,
immediately
there
when
was
an
no
event
stage.
is over.
But I did want to clarify that this is not like Yankee Stadium, because here this is a common area in the park that all of the residents have access to whenever they want. So the fact that the event ends did not give the association the ability just to kick everybody out. They were there because they were residents and this was their home, not just because of the event.
Are you arguing that you did not control the field where plaintiff fell?
Correct, yes. Because neither the lease nor the common law imposed any sort of obligation. Control over the premises, I think the most on-point cases are the Venduro case versus Port Authority, and then also the Third Department's case in Masterson versus Knox. And both of those look at whether a licensee has control over the premises.
So counsel, you're arguing that EPAA didn't have an indemnification obligation with respect to EPOC. Wasn't there provision in Lease Rider 27 that there was an indemnification requirement by EPAA for any area allocated to or used by EPAA?
Yeah, so I was talking about the negligence provisions, but yes, there's an indemnity claim too, and we think that doesn't apply because when you look at the language of the indemnity provision, it does extend to areas outside the mansion, which was the leased premise, but it has to arise out of the use of the mansion, and there's no claim that it does arise out of the use of the mansion.
Thank you.
May it please the court, on behalf of EPOC, Marcy Mitkoff. Your Honors, it's very clear that EPAA was in charge of this event. Not only were they in charge, but the year...
field? I mean, you're the owner of the property, so aren't
Correct, Your
you responsibility as the owner of the property for potential holes in the field that cause someone to be injured? Isn't the ultimate responsibility on the owner?
Your Honor, this wouldn't have arisen but for the fact that this event was going on at the time. Not only did
But it also
EPAA
arguably wouldn't have arisen if there hadn't been allegedly a hole which caused it, and doesn't your client have some responsibility for a hole that could cause an accident?
But, Your Honor, they inspected the property before their event, and not only as part of their inspection, should they have noticed that there was a hole, or in this case, several holes, but the year before at the same event, the plaintiff complained to EPAA of the holes. There was never any complaint made to EPOC. The complaint was solely to EPAA. And under those circumstances, EPAA had a duty to make sure that there were no holes. They were on notice of the hole from the year before, and they should have taken action.
Counsel, what say you to the argument that was just made that there was no indemnification owed by EPAA for its use of the field because lease rider 27 pertains only to the leasing of the mansion?
I disagree with that, Your Honor. I believe that the indemnification does extend to the field where this Labor Day event was going on, and it should extend to that.
Does the language in the lease rider limit the indemnification duty to the mansion area?
I don't believe so, Your Honor.
I see that said allocated to or used by, which seems to be more expansive.
This is still arising out of their use of the EPOC premises. So under that, they should indemnify EPOC.
Thank you.
Thank you.
Second Child versus Edgewater.
Good afternoon, and may it please the court. Walter Santiago Jr. on behalf of appellants Second Child and Daniel Jaffe. The issue before the court is whether the Graves Amendment preempts Vehicle and Traffic Law 370's mandatory minimum insuring obligations in connection with the text of that statute indicating that those minimums shall inure to the benefit of every permissive user of those vehicles.
Let me ask a question. Is it your position or understanding that the Graves Amendment prohibits a state from imposing any vicarious liability on defendants such as this?
Your Honor, what the Graves Amendment does is it preempts vicarious liability that was previously imposed by Vehicle and Traffic Law 388. That's the peremptory effect of the Graves
Right, but
Amendment.
we're trying to figure out 370 now. We know we've already held that 388 is preempted. But why does 370? What is the meaning of that carve-out provision? Because does it allow a carve-out when it would in effect be imposing vicarious liability on the car leasing agency?
In good point, Your Honor. It does have that savings clause for financial responsibility laws of the state,
which is what we're struggling with. So that's
yes, which is Vehicle and Traffic Law 370, and that's exactly what it does. It keeps that intact, so it has no peremptory effect on VTL 370. The text of the statute, VTL 370.
Just so I understand it, is your position that that savings clause allows 370 to exist even though it is in effect opposing vicarious liability on the car rental agency?
So what it is that say the issue is not vicarious liability, and that's exactly what the lower court did here, as did respondents. They improperly conflate vicarious liability with primacy of coverage. Vicarious liability is not the issue, it's primacy of coverage.
Just so I understand, by 370 existing, and 370 does impose, as per the Court of Appeals, primary liability, so aren't they in effect being required to provide coverage for vicarious liability by virtue of it being primary and they're not being negligent? And is that allowed under the Graves Amendment?
So the two could be parceled out. It's comparing apples and oranges. There's a difference between vicarious liability and there's a difference between primacy of coverage. And the legislator understood that when they put the word shall in there. That's a command from the legislator that it shall be done, that primary coverage shall be afforded to these renters up to the minimum amounts prescribed in the statute. And those that was set forth in the cases of Morris, Elreg v. Ward, and most recently in the case of Dynamic v. Penske that was in the lower court.
Wait, so it says, they shall do it, but why isn't that, I'm still not sure what your argument is, that that's not imposing vicarious liability?
Because there's no vicarious liability being imposed, it's imposing primary insurance obligations that are set forth in the statute. And to rule otherwise is to
even though they were not negligent in causing the damage.
even though they were not negligent in causing the damage. And Your Honor, New York has a whole basis of insurance that's premised on the lack of fault or the absence of fault, and we literally call it no-fault insurance.
You're saying this is an example of no-fault insurance, that as to the underlying accident, it wouldn't really matter whether the people who rented the car were negligent, were not negligent, whether the other car was negligent, that this would come into play as primary insurance no matter who is at fault in the underlying accident?
No matter who was at fault, it would be primary coverage up to the minimum amount. So rental car
It has nothing to do with fault, it has nothing to do with vicarious liability.
has nothing to do with fault or vicarious liability. These minimums have to be provided.
So does it come, I'm sorry, let me just move it. Does it come into play, this liability under 370, even when the person who was renting the car was not at all at fault in the accident?
I'm sorry, Your Honor, can you say that?
If the person who was renting the car was not at fault in the underlying accident, it was concluded that they were not at fault, would that insurance still come into play as basically a no-fault insurance?
Well, if the person was not at fault on it, then I would assume that the rental car company could perhaps maybe go to the other person's insurance and say, hey, you should be primary and not us, because there was no wrongdoing here on either part. But that's not the instance here, and the underlying facts are not disputed. The only thing in dispute right now is a pure question of law as to the primacy of coverage. And that issue has already been decided previously by other courts pre-Graves Amendment and post-Graves Amendment by the New York Supreme Court in Dynamic v. Penske, where that court held without any uncertain terms that the Graves Amendment does not change the analysis set forth in L. Rec v.
That's
Ward.
not binding on us, so we have to figure out whether that's correct.
Correct. And it also does not include application of the McCarran-Ferguson Act. None of these cases do, so that's really a matter of first impression that the lower court did not even address. The McCarran-Ferguson Act states that no act of Congress shall impair, invalidate, or supersede any state law enacted to regulate the business of insurance.
I want to provide a hypothetical to you. So the driver of a rented car has insurance, and the car rental agency has insurance pursuant to 370. There's an accident. Who has the primary duty to defend, and who has the primary duty with respect to coverage?
So with respect to coverage, the primary would be the rental agency, and that's up to the mandatory minimums. They can seek indemnification, but it has to be for amounts that are above the mandatory minimums, not within. With regards to the duty to defend, that was also addressed in L. Rec v. Ward, which was before the New York Court of Appeals, and they stated again without uncertain terms that the primary coverage under Vehicle and Traffic Law 370 also includes a duty to defend. So in going back to the McCarran-Ferguson Act, there's a three-part test to determine whether that act applies. It's whether you have a federal statute that does not specifically relate to insurance. And here we have the Graves Amendment that was enacted solely to preempt vicarious liability previously imposed by VTL 388. You need a state law that was enacted to regulate the business of insurance, and that's exactly what VTL 370 does. And the last part of the test is that the federal law would impair, invalidate, or supersede VTL 370, and that's exactly what respondents
How would it
are
do
arguing.
that? How would it invalidate 370?
Because it would nullify the peremptory mandate that insurance shall inure to the benefit of every permissive user.
I know we're done, but can you just walk through one more time your explanation for why you think the carve-out applies in this case to 370 from the general provision that you can't impose vicarious liability?
Absolutely. And in order for me to couch it, I'd like to just start by saying the Graves Amendment solely precludes vicarious liability previously imposed by VTL 388.
You
What
don't
it
think
does not
it
do
even
is it does,
addresses 370.
yeah, what it does not do is it does not preempt VTL 370. It does not preempt its mandatory minimum insuring obligations, and it does not preempt the peremptory mandate that they shall inure to the benefit of every permissive user.
Okay,
Thank you.
thank you.
Good afternoon. May it please the court. Eric Mercurio from Maziakos, Mercurio and Associates on behalf of the respondents, Edge Auto and Maya Insurance. It is well settled that the Graves Amendment can both protect and shield the lessors of vehicles while also permitting states to impose the minimum insurance requirements. It is equally well settled that requiring a lessor to indemnify its renters for their own negligence runs afoul of the Graves Amendment.
Why doesn't it come, he's arguing it doesn't come into play at all, but why, first of all, why doesn't it come under the carve-out?
Appellant's interpretation basically allows the carve-out to be an exception that swallows the rule.
Well, the other statute is clearly an exception as such. If 388 was still in play, that would be an exception that swallows the rule, because that imposes vicarious liability. But isn't there a true and real distinction between 370 and 388? That 370 is a narrowly tailored obligation that requires a minimum insurance for car rental agencies, which is the exact opposite of 388, which is a wide imposition of vicarious liability.
So, again, the appellant's interpretation, basically, it creates a backdoor to coverage that undermines the Congress's intent with regard to the Graves Amendment. It's saying you're not vicariously liable, however, you're still entitled to coverage through primacy of coverage. It's just a backdoor way around, and it,
What do you think the carve-out
undermines
means?
entirely the Graves Amendment.
What do you think the carve-out means? If it doesn't mean that it protects the law like 370, what does it mean?
It means, so states are allowed to have statutes that require owners of all vehicles that are on the road to have insurance as part of their registration and licensing requirements. So as an owner of a vehicle, they have to have insurance. If the vehicle is being operated by someone who's not a renter, or maybe an employee of the rental company.
Isn't that what Effect 370 is? Isn't 370 a statute that says all owners of vehicles have to have some insurance on their vehicles, including car rental agencies?
They can have insurance on the vehicle, but that doesn't require that the insurance cover the renter's negligence or when the renter is involved in the vehicle.
But isn't that exactly what Ward held, that that's what 370 does?
To the extent that a renter is using a vehicle, the Graves Amendment does protect the lessor of the vehicle. Nowhere in 370 also does it say that the coverage has to be primary and non-contributory.
That's what Ward says. That Ward has interpreted, the Court of Appeals has interpreted 370 to mean exactly that.
That was pre-Graves. Ward was
right, but 370 says what it says.
But that was prior to the Graves Amendment being.
You're saying part of 370 should be invalidated because they've already held what it means, and you're saying we should change what it means now post-Graves?
It is partially preempted by the subsequent enactment of Graves.
So, counsel, let me understand you. And I'm basically going to ask you what I asked your adversary. There's a car accident and the driver has insurance. The car rental agency has insurance. Under the understanding posed by counsel, the car rental agency has to defend and has to provide coverage up to the minimum. Under your analysis, it would go the other way?
Yes, per the rental agreement, the renter is required to have insurance, and per the agreement that is signed by the renter, it's a contract signed by the renter, they've agreed that they will obtain insurance, and that insurance will be primary over the rental agency's insurance.
The agreement doesn't, between the lessor and your client, doesn't specifically provide for who has primary insurance coverage.
My understanding of the rental agreement, there was a paragraph that did say that it was the renter's insurance that would be primary.
It says that in the contract?
Yes. It's my understanding. If I'm wrong, I apologize, but it's my understanding that it does say that.
Thank you.
Thank you.
Could you just follow up on that? Are they done?
He has a minute.
Yes.
Could you just follow up on that? Was there a proviso in the car rental agreement that the driver's insurance was primary?
Yes, Your Honor. It's my understanding that the rental agreement does include that provision. However, that is an issue that's been litigated back since, I believe, 1994 when it first came up in Morris v. Snappy. And the Court of Appeals held there that a rental company can seek indemnification, but
They
can seek indemnification, but it has to be for amounts above the statutory minimums,
Right.
not for amounts that fall within the statutory minimums. And again, that came up in LRAC v. Ward,
Right.
again in Dynamic v. Penske before the New York County Supreme Court, where they held that the Graves Amendment does not change the analysis set forth in Ward. All the cases cited by the respondents, they are all from out of state. They all relate to VTL 388. The only one that touches on 370 is dimensional, and that case decided vicarious liability. It didn't decide primacy of coverage.
Thank you very much.
Thank you.
Is there any more questions? 244 Madison Realty versus Utica First Insurance. I'm sorry, I started your time, but I'll start it again.
It's okay. Good afternoon, Your Honors. My name is Susan Mahan from the law firm of Gartner and Bloom. I'm here for the appellants 244 Madison Realty and Maxwell Cates, Inc. We're appealing the May 2022 decision and order of Justice Knock in the court below that ruled that Utica First, cross motion for summary judgment was granted and declared that Utica First had no obligation to defend 244 Madison in an underlying personal injury action. We believe the court below erred when it so held because that Utica First was prejudiced by late notice in the underlying personal injury action. This court in Salvo versus GNY held that the plaintiff was entitled to a defense and indemnification from GNY, notwithstanding that notice to GNY was 4 years after the accident, that the plaintiff
Well, let's start with the fact that under the law, it's clearly more than 2 years, so the burden is on you.
Yes.
How did your client meet its burden of showing no prejudice, since the burden was clearly on your client?
How did we, what we can show is that the underlying action is ongoing. That we are, that.
Sorry, could you talk closer to the microphone?
I'm sorry, Your Honor.
Trouble hearing you.
What we can show is the underlying action is ongoing. There's no judgment. There's no settlement.
Right, but they did not get the opportunity to be involved at an earlier point where they could have done fact-finding about the case, talking to witnesses, examined the site, different things that you can do earlier on in the case that you can't do later in the case.
Well, respectfully, Your Honor, I have to disagree because the respondents, Mr. Capanos and Purgos Foods, were actually occupying the premises where the accident occurred. This was the Moonstruck Diner on Madison Avenue. They were occupying, controlling, maintaining.
We're talking about the insurance company, aren't we? I'm sorry.
The insurance company, they're insured, occupied the premises. It controlled the premises. It was their insured employee who got hurt. They are in a better, Utica First insured is in a better.
The question is whether maybe I'm missing something. Isn't the question whether the insurance company was investigating the claim at that point?
The insurance company, all it had to do was contact its insured to find out what were the maintenance records, what were the
Don't you have to give notice? I mean, insurance companies don't just call up their insureds and say, hi, do you have an accident today? We should come and investigate. I mean, that's not how it works.
No, I understand that, Your Honor, but also the Utica First insured had an obligation to notify its carrier, Utica First.
But the question is at the starting point here is the burden is on your client under the statute. So your client has a burden to show lack of prejudice.
Right.
So what are you putting forth? If you could show lack of prejudice just by saying the insurance has a relationship with the insured, then every case would have that. So there has to be something more than that.
Your Honor, the more than that is that this case is ongoing, and as I said earlier,
Right, but again, it's ongoing, but even if they went and contacted their insured now and said, hey, we want to come inspect, we want to talk to the people, it's years later. It's not fresh anymore, the evidence.
well, let's, if I may put it in some perspective, they were brought into the underlying action in 2018 when discovery was still ongoing, when the
But the
plaintiff.
issue then was indemnification, right? Not investigation of the tort claims themselves.
I'm sorry, Your Honor, I missed the first part of that.
The issue then was indemnification for the insurance company. It wasn't an investigation with respect to the personal injury that was sustained and so on and so forth, right?
Right, the third-party action is for indemnity and contribution, but you defend a third-party action for indemnity and contribution the same way you would defend a direct bodily injury claim. You want to know what the plaintiff's injuries are, what was the causation of the injury, because that will impact how the indemnity, whether the indemnity is going to flow down from the owner to the Utica First insureds, that those entities that were in possession and controlled and maintained the premises where the underlying plaintiff was injured. And if I just may very briefly address the separation of insureds argument, Your Honor, that was raised by Utica First in their reply papers, 244 Madison was under no obligation to assume the tort liability of another, which is the trigger of all of the exceptions to the Utica First employee injury exclusion. Utica First policies don't cover employee injuries except in the instance of an incidental contract. In the definition of, in the policy itself, an incidental contract is defined as a lease of a premises. That incidental contract definition is expanded by a contractual liability coverage endorsement.
I'm going to let you go
I'm
on
sorry,
in your rebuttal time on that
Okay,
point, if you
thank
want to
you, Your Honors.
continue to discuss it. Oh, you don't have rebuttal time. But we've read the briefs and we're familiar with the arguments.
I'm sorry, Your Honor.
You don't have rebuttal time, I just realized, but.
Okay, Your Honors, I have a hearing impediment. I wear hearing aids, which are turned all the way up, but if you could talk directly in the microphones, that would be wonderful, because I don't pick up on everything, unfortunately. Okay, I'm here on behalf of Utica First, which is the defendant respondent in this case. This is, to use some hyperbole, an egregious late notice case, 5 years.
So why was your client prejudiced?
Okay, let's get to the prejudice. Well, first of all, as some of you were mentioning, there was at least 2.5 years before, or rather it was five years before we learned of the accident, okay? In that this is a leaky pipe into a soda machine in a diner in Midtown Manhattan. There was a repairman, this guy named Salvo, who worked for the building, not for the restaurant, who would be called in every so often to tinker with it, and he would futz with it and this and that or the other thing. The point of the matter, it was a completely transitory situation. Under the statute, prejudice is shown, one, if in the investigation, and second, in the defense. So, but both apply here. It's an either or under the statute. But we had zero opportunity to look at a completely transient situation, and it's completely different from Salvo, where one of the board members of this condominium in the Bronx said that one of them wasn't paying their maintenance charges for a long time, and that was it. What she said, or if she said that, and we know who she talked to because it was whoever was on the board. So it was a very static situation. This was a completely changing situation. The guy was constantly coming in to work on it. The restaurant would complain to the building, this guy Salvo, whose last name is unknown, whose whereabouts is unknown. According to the plaintiff, she doesn't know if he's dead or alive, right? So the point of the matter is, one, zero opportunity for 5 years in a changing situation, conditions, inability to investigate, and you may have noticed that in
Counsel,
their...
your adversary says that there's no distinction between the investigation that would have been undertaken by your client within the realm of indemnification, as opposed to the investigation that it would have undertaken within the realm of tort claims. It's the same investigation. If it was...
It can't possibly be the same investigation. The machine and the pipe situation was constantly changing, and it was constantly being tinkered with and repaired. So 5 years later, we couldn't go in there and conduct an inspection of the premises because we wouldn't have known what was going on. Yes, it's true, the restaurant was there, so they had some knowledge, but in fact, it was the buildings person, this Angelo, identified and discussed extensively by the plaintiff in her deposition, which, by the way, was held before Utica First was even in the case. And then in terms of defense, they being GNY essentially was pointing the finger and attempting to shift liability onto our client, and the restaurant or the tenant. And we argued that that this is that under the law, I apologize. Under the anti-subrogation statute, Utica First could not sue its own insured, okay? So you have GNY, who's in there targeting the restaurant this whole time, who's another one of Utica First's insureds, and under the basic principle of anti-subrogation, we could not have even brought that lawsuit. That third-party action that existed couldn't have existed if we had been timely informed, assuming the employee exclusion, didn't apply, which we believe it did. But even assuming that for the moment, we wouldn't have been able to bring the third-party action. So the whole way the case was defended was completely contrary to how it would have to have been handled by Utica First.
Thank you very much.
Thank you.
Block versus Stern.
Good afternoon, Your Honors. William Natbeny from Cadwallader, Wickersham, and Taft on behalf of Appellant Arthur Stern. Where Supreme Court went wrong, Your Honors, is by determining that this was one loan of $330,000, period. What the Supreme Court ignored were four key factors that show that these were two loans for $165,000 at a usurious rate. And the four factors are as follows. First, this promissory note on its face says that it's $330,000 to be divided in equal shares. Now, why is that language there?
When he did the affidavit acknowledging his default and consenting to judgment on the loan, didn't that document indicate that the loan made to defendant was a total amount of $330,000? Isn't that pretty conclusive proof that it was one loan for $330,000 rather than two loans?
I think, Your Honor, you've got to deal with the promissory note on its face. And the promissory note on its face has these four indications. First, what's the language of equal shares? Why is it there? I mean, if I'm making a loan for $330,000 that's going to be for two people, you say, I'm making a $330,000 loan to Mr. X and Mr. Y.
So, counsel, you're asking us to speculate. I mean, it could be that one person has less income than the other, or fewer assets than the other. It could be something very personal. Why should we speculate as to how the lenders decided to have priority with respect to repayment?
Thank you for your question. With all due respect, I don't think it's speculation. I think it's looking at the face of the agreement. What is the purpose?
The agreement says it's a loan for $330,000. I mean, if you go to look at the promissory note, it indicates that it is a loan for $330,000, not multiple loans for various.
Well, it says a loan of $330,000 in equal shares.
Why isn't that conclusive? Because it says a loan of $330,000.
Well, because first of all, it says in equal shares. Why is that language there, as I said? Secondly,
To show
there
how
are-
they should be paid that $330,000.
But secondly, in the reliance here on the other side by using the word holder, right? If I'm going to use the word holder, I'm going to say the holder is Mr. X and Mr. Y. It's not what it says here. It says each is going to be a holder, not both. The promissory note says each. So again, it's each loan, each $165,000. And look, what did Mr. Wack do here? Did he sue for $330,000? No. He knows he's only responsible and only able to get $165,000.
Counsel, wasn't $168K already paid? Didn't that leave the balance?
No, but his complaint alleges the $165,000. It doesn't allege.
But doesn't that reflect the balance that was owed?
I understand,
Because there
but it
had been
doesn't.
payments.
He's not indicating that he is responsible for he's able to get the 330, and that's
So
the
under
whole
under your analysis, he should have sued for the full amount, even though part of it was paid?
He would, if he should have sued for the amount that was due and owing, and at that time, now it's been paid. But I mean, the problem is, and I still haven't gotten to the fourth one, which is there's a different schedule here, right? I mean, you're not paying all of this at the same time. You're paying it at various times. When you look at the four, even the settlement agreement, let's talk about the settlement agreement. If you look at section 1.2 of the settlement agreement, it talks about what money is owed to various people. And it talks about not the full amount being owed to each, but the portion of the amount. So Jacobs only gets a certain amount owed to Jacobs, not the full amount of the 330. So look, our view, and I appreciate Your Honor's questions, is that the face of the promissory note is what you need to focus on. Those four indices, show that they're independent loans. When you talk about the consent judgment or the settlement agreement, those just incorporate the terms of the promissory note. If the promissory note falls because of the usurious rate, so does the consent judgment, and so does the settlement agreement. You can't take a usurious loan that's illegal and turn it into a legal loan by a settlement agreement.
So under your argument, if there's a loan for $500,000 at 18% interest, and $400,000 is paid, leaving $100,000, the interest rate is usurious because the amount owed is less than $250K?
Our point is that the loan itself would have been void ab initio because it's a usurious rate.
No matter how much it was?
Well, no, it has to be under the statute. If the amount of the principal loan is within the confines of the statute, then it's illegal. And here, the 165, the independent loans, were within the threshold to make it illegal.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Michael Munoz for the plaintiff respondent. The question before this court is whether the lower court erred in applying the exception in GBL 5-5016A that my colleague referred to. And my colleague has put forth the novel theory that analysis requires focusing on the nature of the lenders and the agreements between the lenders as to how they are going to split up the proceeds of the loan payments and the payment instructions that they give to the plaintiff. The statutory exceptions focuses on two things. The exception applies to any loan or forbearance in the amount of $250,000 or more. There's not a mention of how many people are funding the loan. There's not a mention of how the loan is to be paid, whether it's paid in one check per month or two checks per month. It talks about, is there a loan or a forbearance in this amount? And as Your Honor correctly noted, look at the face of the promissory note. There is one principal amount. There is one interest rate, there is one set of terms. There are two people funding the loan, and as the settlement agreement decided to, by the appellant points out, has agreements between Wacht, my client, and Jacobs, the non-party, as to how they are going to prioritize those payments. It has nothing to do with the plaintiff. We're here, I mean, excuse
Oh,
me,
I have
with the
a
defendant.
question.
Yes.
So I'm looking at record page 47, at Article 1 settlement payment, and it says that Wacht was supposed to be paid first. Am I right?
Correct.
And Jacobs was supposed to be paid second.
Correct.
Okay, so this case is brought by Wacht, right?
Correct.
But $168K or thereabouts was already paid out of the $330?
I'm not sure what, I think that's about right, yes.
Okay, so is there any argument made at any point that Wacht had no standing to bring this because in fact there were two separate loans and Wacht had already been paid?
Well, what's alleged in the complaint, and I believe it to be true, is that there's an outstanding balance owed, and Mr. Wacht is seeking his half of that outstanding balance. He's not entitled to seek the full outstanding balance. Those are not, it would be dishonest for him to come into court and say, I've been injured by 2X, when he knows that he's only entitled to receive X under the loan. And so no one's raised a standing issue to date, and I don't think that there is one, and I think the face of the complaint will lay that out. If I may just end with this, Your Honors, the point of these usury laws is to avoid unfairness to the plaintiff. That's why we focus on, is the plaintiff sophisticated? What is the nature of the loan? What is the amount of the interest? Who on the lending side ends up with what amount of the loan payments has nothing to do with the plaintiff, with the borrower. The borrower is in the same position he would be in whether Mr. Wacht by himself made the loan or whether, as was here, there were two funders of the loan. The unfairness of usury does not arise because of that circumstance, which is the only circumstance that the appellant relies on in trying to argue that these are two separate loans.
Thank you.
Unless there are any other questions, thank you.
Thank you, Your Honors. Three very quick points. First, you heard counsel for Mr. Wacht admit to you that his client was only entitled to one half of the $330,000. That was his portion of the loan,
But
the
that
$165,000.
But that doesn't necessarily mean that there were two separate loans. He was entitled to only a portion of the loan. I mean, you're trying to say it was of two loans. They were together. Two different people were entitled to.
I think what counsel basically admitted was that it was not a $330,000 loan from Wacht. It was a $165,000 loan, and that's all he was entitled to. Secondly, he talked about the promissory note talking about only payment instructions. Well, the payment instructions are in a separate section, in Section 1. When you're talking about equal shares and the definition of holder, which talks about, again, each, not both jointly, but each, that's in the preamble in the beginning of the promissory note, not near that section. And finally, Your Honor.
Thank you.
30 seconds?
No, we're familiar with the arguments.
Thank you. There are obviously policy concerns here.
Thank you.
Thank you.
Talken Capital versus Omanoff.
May it please the court. Your Honors, my name is Tom Feeney on behalf of the appellants. Thank you for your time today. The main key issue in this case boils down to a fundamental, simple legal rule, which was violated in this case, which is that when there is an entity that is no longer in good standing, the party that's purporting to reignite or put the entity back into good standing needs to have a proper authority to do that. And
We do have to focus, though, on the way things came up, because there was a motion to dismiss, there was a motion to amend. So because we have to follow those parameters, I'd like you to focus your argument. Well, I'd like you to start on the motion to amend. Why don't we start there? whether that motion amend
The motion to amend, Your Honor,
should or
is...
should not have been granted, since they
the
all
mo-
come
the-
up on the
the-
appeal.
The motion to amend is the key issue on this appeal.
Okay, so
when-
tell us why that should not have been granted, and what would be the effect if we agree with you that the motion to amend should not have been granted?
Well, the motion to amend attempted to replace Forefront and swap in Talken Capital.
And was granted.
But it was granted over an objection.
Right, so why was that wrong?
The reason it was wrong is because both of those entities were no longer in good standing, and the person who purported to put them back into good standing, Brad Reifler, had no authority under the operating agreements. Once he had
Plus,
filed...
he had filed for bankruptcy.
Because he had filed to bankruptcy. Now, in addition to that, Mr. Reifler engaged in so much wrongdoing that he's now serving in a prison sentence. The bottom line is he tried to manipulate these companies, and at the end of the day, the defendants in the brief in the record, it's 4195, the memorandum of law in opposition to the motion to amend, at record 4212, the defendants clearly laid out the operating agreement provisions, which said that Brad Reifler no longer had authority. And under this court's decision, Favorite Limited, this court very recently, in 2020, Favorite Limited versus SECO, 181 AD 3rd, 426, clearly held that when a member purported to reignite the entity, the member did not, he lacked authority on behalf of the company under...
Let me ask you something. Let's say we agree with you, and we find that the motion to amend should not have been granted. What happens then to the case?
What happens to the case? Well, the case gets remanded. And by the way, to answer your question, the plaintiff's counsel repeatedly says that there wasn't a cross motion to dismiss. You didn't need a cross motion to dismiss. The defendants...
You mean for it to come up on appeal?
The defendants opposed the motion to amend. This is properly on appeal. That's what, and so that's the issue. It's properly before your honors. If you follow the law, if you follow your precedent in Favorite Limited, you remand the case back to the lower court. Now the lower court is in a position...
Does Forefront become the plaintiff again?
Forefront would be, if the claims are not time-barred, there's going to be a very interesting issue as to whether there was tolling. We will argue there wasn't. This is an issue that it went up, when Favorite went
Not
up...
on this appeal.
Well, it's not this appeal, but in front of that
Does a new
court...
manager have to be appointed first?
I'm
Does a
sorry?
new manager have to be appointed for Forefront first?
Well, our theory of what should have happened here is that once Reifler, the criminal convict who's now in prison, filed bankruptcy with all of his victims, at that moment, he, under the operating agreement, was not the manager. And what I would do is go to the bankruptcy trustee.
Wait. Let's go back to more practice. I know, but right now, we are where we are. So you're talking about what...
Right, it would go
what you
back to
wanted
answer,
to have
to answer your
happen in the
question first, and
past.
I'll happy to answer yours. To answer your
Right,
question,
but
it
right
goes
now
back to the
question is
lower
very
court.
practical. What happens
It goes
if the motion to amend is vacated?
vacated, then
What happens in this case going
then Forefront would have been the proper defendant all along, and Forefront had the unclean hands. Forefront
But that hasn't been, that issue has never been decided yet.
never been
Because
decided, so we'd have to
We only decided
litigate.
and affirmed as to Talken Capitals. So would there then be a new round of summary judgment motion?
There would be a new round, absolutely. There would be a new round of summary judgment based on the fact that Forefront, which engaged in unclean hands, is the proper defendant, is the proper plaintiff, and the defendants have the right to now say, wait, you engaged in unbelievable unclean hands. You're not allowed to sue me.
You'd get the right, theoretically, if we reverse the motion to amend, to re-argue the issue of unclean hands as with respect to, or
We would have the right to argue the unclean hands as with respect to Forefront. Now, Your Honors, the
and
other...
that's the relief that you're ultimately seeking here.
Yes. Now, I do want to make sure, Your Honors, I do want to address the bankruptcy court decision, because the plaintiff tries to argue that the bankruptcy court decision, which is it's Reifler, In re Reifler 2023, Westlaw 5510233. The plaintiffs argue that as a matter of res judicata, the bankruptcy court ruled that Reifler is the appointed manager. The bankruptcy court and the district court did not rule that at all. The issue in that case was whether because it's solely owned, it's a solely owned subsidiary, the action, the state action, is property of the bankruptcy estate, and the court went through a very technical analysis and said that since it was a manager-membered entity, it was not. And in passing, it referred to a statement of fact that the plaintiff had alleged that he was the manager, but it did, the outcome of the case did not turn on that. It was never litigated. Moreover, this is from 2023. We're talking about an error that the court made in the decision from 2021. In 2021, there was nothing before the bankruptcy. There was no, this decision does not exist. And when this decision was issued, the court made very clear at page, page 9, pinpoint 9. So even if the trustee did somehow automatically become manager of Forefront, that would not make the TC Company's assets of the Reifler's estate. The court was saying, whoever was the manager, it's manager, it is manager, it's managed by a manager, not a member. It's not member managed. So whether it was the trustee or whoever it should have been, it's not property of the estate. So this is very important because this is really their main argument. Their main argument is we didn't make a cross motion and the bankruptcy decision. Otherwise, you have pure law of favorite limited, Your Honors. Thank you.
Good afternoon, Your Honors, and may it please the court, I'm David Bowles for the respondents. I'm surprised to hear that the main and key issue is the order about amendment of the complaint, because that's an easy one. Complaints can be amended absent prejudice or surprise. There was no prejudice or surprise.
What about the argument, though, which is the primary argument they're making, that it was incorrect substantively to allow the amendment because all the companies were canceled at the time the amendment was made?
Importantly, this was the first time in 2021 that they had raised this issue. And as soon as they raised this issue, not in a cross motion, as my opponent admits, but in opposing papers, my clients cured that issue right away.
Right, but the question then becomes whether that cure was a valid cure and whether your client had the ability at that point to effectuate that cure with the written consents and whether those written consents were valid. And obviously, they're arguing they weren't valid. So
the written consents are not. Those were belt and suspenders, Your Honor. Brad Reifler was the manager of the company at that time. Despite what they say, it has been thoroughly litigated only in the federal court, not in the state court, only in the federal court.
When was a determination made that he survived being the manager once he filed for bankruptcy?
The decision was made in 2023, but that's the only time it's been litigated. And standing here today, that is res judicata or at least collateral estoppel, because there's only one place that issue has been litigated, and it was decided by the federal court. And despite what they say,
You're saying that the bankruptcy, you're disagreeing. He's saying the bankruptcy court did not decide that issue, and you're arguing the bankruptcy court did decide that issue, and that's what you're referring to by the 2023 decision.
It was clearly decided by
We need to decide what we think that bankruptcy court did or did not decide.
It's really the Southern District on Appeal that did an exhaustive analysis of this issue, and despite them calling it dicta, it was not. This was central to their case.
So if we disagree with you and we hold otherwise, then what happens?
Your Honor, I would say that this should not be raised for the first time on appeal.
The amendment issue?
Not the amendment issue, the question of whether Mr. Reifler was continued to be the manager. The only place it's been litigated.
Doesn't that issue have to be decided for us to decide the issue of whether or not the amendment should or should not have been granted? Doesn't that go to the substance of that argument?
I would say again, Your Honor, res judicata and collateral estoppel. If this court were to decide it in the abstract, then it becomes a factual issue that should be presented to Judge Schechter for a decision.
You're saying the bankruptcy court decision is res judicata, or?
Southern District's Court on appeal from the bankruptcy decision.
Right, that's what your argument is, res judicata. Okay.
That's res judicata, Your Honor, because same parties or related parties litigated this to the ends of the earth, and there was an exhaustive decision by the Southern District of New York that held clearly that Mr. Reifler, not some random unnamed manager, that Mr. Reifler remained the manager of the company. I think that should be binding on the court. It should be res judicata. It was litigated between the parties. And importantly, it was not raised and litigated before Judge Schechter. They are asking for this case to be dismissed for 7...
So it's not correct that that the bankruptcy court held that Mr. Reifler's managerial powers and responsibilities were not property that passed to the bankruptcy state. They said that, but did they analyze the effect of the bankruptcy filing on Mr. Reifler's position as a manager under the terms of the operating agreement?
Yes, that was fully briefed to the bankruptcy court and to the
Was that
Southern
fully
District.
decided?
The court did not expressly say anything
I
about
was
the
going to
operating
ask you to
agreement.
follow up on that. Where in the court's decision did they decide that specific issue? What's your citation to that decision that specifically addresses that issue, which is the dispositive issue?
That issue was not mentioned by the Southern District of New York.
Following up on
How can it be res
judicata? How can that be res judicata if they did not specifically decide that issue, which is a pivotal issue that we have to decide here? How can it be res judicata or collateral estoppel?
Southern District heard it and decided that Brad Reifler was the manager, having heard the briefing on this issue, and it was exhaustively briefed. The conclusion was that Mr. Reifler remains a manager to this day. If this were litigated anew, I would argue that the operating agreement, 6.2 of the operating agreement, says that Mr. Reifler, not the member, but Mr. Reifler, has the ability to appoint two managers of the company.
Counsel, what's the citation, please, where the Southern District says that Mr. Reifler continued as manager, notwithstanding the filing of the bankruptcy?
Only can cite generally to the case. I can't cite you to a page of it, but it says it thoroughly on several pages that Mr. Reifler remains the manager of forfeit
You have that in your brief?
It is in the brief, Your
At
Honor.
what pages of your brief, please?
I don't have it off the top of my head, Your Honor. I apologize. But it is briefed and it is cited there as to where and when the Southern
Really
District
more
says it.
concerned with not your arguments, but what the court said. You said res judicata.
Yes,
Those
Your
are
Honor.
powerful words.
Yes, Your Honor, and I think it's exactly right, because this was thoroughly briefed to the Southern District, and the Southern District decided it, and decided clearly, not in dicta, but that Brad Reifler was the manager of the company, and is the manager of the company. Being the manager of the company, he could properly restore the company to good standing. My opponent has cited Favorite. Favorite is easily distinguishable. That was a case in which a member acting alone tried to restore a company to good standing in the state of Delaware. The court decided a member standing alone could not do so. It was returned ultimately to the state court. It went back to the Court of Appeals and was sent back, and ultimately they were able to prove to Judge Schechter that there was authority to do so, and the case continued. That is a waste of judicial resources here. This has been determined. But in any case, again, I would cite the court to 6.2 of the operating agreement to see that Mr. Reifler does have the power, and it's critical, the language in there, not the member of the company, but Mr. Reifler has the power to appoint two managers. If the court
But
were
he
to
has the
conclude-
power while he's a manager, correct?
I'm sorry, Your Honor?
He has the power to appoint other managers while he's a manager.
He has the power as himself to appoint managers of the company. Our argument would be, if we had to litigate this again,
But what if he loses his managerial position because he files for bankruptcy? Then what happens?
our argument would be that either by implication or expressly, he did reappoint himself as manager, and there's no prohibition on him doing so.
So he can do that. So
can do that.
he can lose his managerial position by filing for bankruptcy. According to the operating agreement, he would lose he would stop being a manager, but he can still go ahead and say, well, I'm appointing myself a manager again.
Yes, Your Honor, and I think
Wouldn't that
the
make
only...
that provision meaningless?
I'm sorry?
Wouldn't that make the provision meaningless? If he loses his position by filing for bankruptcy and the next day can just say, I'm appointing myself manager again, what would that provision mean?
It's still in accordance with the operating agreement. LLCs are creatures of law.
They're allowed to have meaningless provisions.
Yes, and the only entity, the only person who could object to that is the trustee in the bankruptcy who assumed member status. And the trustee has been sitting in bankruptcy court, has been briefed on the Southern District case, has never objected, and has impliedly consented to Mr. Reifler continuing as manager of the company all of this time.
You impliedly, no citation to the Southern District, not having a reference to your brief. You're asking us to assume an awful lot.
Your Honor,
Under the aegis of res judicata applies, but it's kind of a secret as to where.
No, Your Honor. I mean, it is very clear from the In re Reifler decision from the Southern District that they did exhaustively conclude that Mr. Reifler is the manager of the company, and that's what we argue is res judicata. It's been decided.
Thank you.
Thank you, Your Honors.
You know what our question's going to be. What does the Southern District decision and the bankruptcy decision say about him continuing as manager or being manager?
Your Honors, in this decision, I think your questions from my colleague were correct in that you zoned in on the critical question. Did the court need to address or resolve that issue, and did it? Did it actually need to resolve that issue, whether or not he was the manager? And did the court, in fact, decide that issue? And the answer is no to both. It clearly did not need to reach that. The whole entire discussion in that very technical analysis is the entity manager, is it managed by a manager or a member? Is it member managed, or is it have you can designate a manager? And for the purpose of argument, the court was saying, okay, let's say he has this management right. It still doesn't belong to the estate. The management doesn't. And the proof of that is the court said, again, at pinpoint 9, so even if the trustee did somehow automatically become manager of Forefront, that would not make the TC Company's assets property of the bankruptcy estate. Also, counsel argued that we're raising something for the first time on appeal. At record 4212, in opposition to the motion to amend, this exact argument was raised. And I think the court is correct in observing there would be a meaningless provision to say you can't act as manager. You forfeit it when you file bankruptcy, and then you can appoint another manager.
Okay, are there any other questions from the bench on this? Okay, thank you.
Thank you very much, Your Honors.
Tibs versus Jalongi.
May it please the court. Stephen Whittam with the Yankwitz Law Firm. I represent the plaintiff's appellants. I'll make this brief. This is a motor vehicle accident that occurred on July 20th, 2018. It is plaintiff's position that the lower court erred in denying our summary judgment motion on the issue of liability. The facts of this case are pretty simple. Plaintiffs are driving on the West Side Highway northbound. They're driving approximately 15 to 20 miles per hour for about 10 minutes when the defendant's vehicle, which is to the left, veers into our car and causes an accident.
So why isn't there a disputed issue of fact about that? Since your client testified that she was in the right 2 lanes and the defendant testified it was in the leftmost lane, isn't there an empty lane in between?
With all due respect, that's not the facts of the case because the defendant's vehicle was in the second to left lane. So the left
Didn't
lane.
the defendant testify that they were in the leftmost lane?
No,
And
so-
that they were moving into?
No.
Pretty sure that's what the defendant testified, that leftmost lane moving into the second leftmost.
No. So what happened was the defendant's vehicle is in the second to left lane. That's a straight lane. The one to the left is a turn lane. So they're
No, I mean the leftmost lane of the lanes going straight.
yes. So she's
And your client was
my
first
client
2
was
lanes, which
my
is a
client's
3rd
going-
lane in between.
So my client is right adjacent to her. My client's going straight. There's a vehicle in front of the defendant's car that is not moving, even though there's a green light. That vehicle puts on a blinker to turn into the left lane. So realizing the defendant can't go forward, she makes an abrupt turn into the right lane where my client is driving. And on their opposition papers, they argue that my client, out of nowhere, drove into that lane as she was attempting to merge into the lane. There's no evidence as to that. In fact, the defendant testified. The defendant testified that the first time she saw a plaintiff's vehicle was at the time of the collision. There's testimony by the defendant saying, yeah, I looked to the front, I saw some vehicles that passed, and I looked to the right. There were nothing in my immediate right, and there's nothing to my all the way to the right. So that clearly indicates she didn't see what there was to be seen. And there is First Department case law directly on point. I printed out 3 of the cases which I cite in my papers. One of them was a defendant admits that she never saw the plaintiff's vehicle prior to impact. This is exactly what happened here. There's another case, January of this year, when a bus, when a plaintiff is driving and the bus is trying to avoid a parked car and goes into the plaintiff's lane, which is driving straight. This department has held that, yeah, that is negligence as a matter of law. And if you notice in the defendant's opposition papers, respondents' briefs, they don't refute any of my arguments. They don't even touch upon the cases.
Thank you. Your time's up.
All right, thank you, Your Honors. Have a good weekend.
Gregoria versus LeCoultre.
Good afternoon, Your Honor. David Slarsky from Slarsky LLC for the appellants, the Gergereb appellants. This appeal presents two issues. The first is whether the IAS court abused its discretion when it accepted respondents' expert testimony as an accounting. The second issue, which is related, is did the court err when it denied our motion to strike that expert testimony? And let me jump into the first issue right away. An accounting is an equitable remedy, and the decision of whether to accept an accounting is a matter of discretion for the court. But discretion must be exercised within the bounds of law and equity. And in this case, the IAS court abused that discretion for two clear reasons. First, the key factual findings, which we've outlined between pages 35 and 40 of our appellant brief, of our opening brief, that the IAS court relied on, cannot be supported by any reasonable view of the record. They are flatly inconsistent with the testimony from the expert, which we've outlined at great painstaking length in our statement of the case. And the second reason why the IAS court erred and abused its discretion is because it did not require the respondents to demonstrate how monies were expended, which is the essence, the legal essence of providing an accounting. So whereas it is discretionary whether to accept an accounting, that discretion is abused when the accounting itself doesn't come within the law, doesn't abide by the laws.
Counsel, no, going into this equitable accounting, there was no question that these underlying documents didn't exist. But it somehow seems like your argument is that they could not have satisfied the requirements from an equitable accounting without having those underlying documents. But then this whole thing was a waste of time because there was no way they were ever going to have those underlying documents, and everyone knew that going into the equitable accounting. So understanding as a given that everybody knew when this equitable accounting began that those underlying documents that you want them to have don't exist, why wasn't their expert analysis sufficient to
Your Honor, I don't think it was
support
a waste of time, and we were hearing from Justices Mendez and Kapnick, who rejected the.
I'm not saying a waste of time. I'm saying it's a given that those documents didn't exist, that equitable accounting was going to go forward without those documents.
Well,
so if the only way for them to satisfy their equitable accounting was to produce those documents, then it would have been a waste. But that's not the case.
Well, the expert actually testified that there are ways of doing an accounting. Typically,
Are you saying that her methodology that she used was faulty in some way? I mean, she gave a lot of information that the...
No, she gave no information. She gave exactly the same opinion. She gave exactly the same opinion that she gave that this court rejected as adequate for an accounting.
But what did you put in through your expert or otherwise that showed that there was any misuse of I mean, I thought by reviewing the expert testimony and what the judge said in the transcript that they looked at the numbers over the years and thought that it made sense. I know there were some checks written out that you questioned where the heck could all that money went, but those were tips to people, and she figured out that came out the right way.
Your Honor.
And that's what she said.
No, she didn't. That's not what the testimony is. That's the first reason why I said the court abused its discretion. No reasonable view of this record can sustain those factual findings. And I encourage the court to line up the IAS court's factual findings against the testimony, where she, on page 104, specifically, record 104, she specifically says she did nothing to verify the tax returns. She specifically says she never looked at any primary source data. Now,
Because
she
it
could
didn't
have.
exist.
Right,
She
they
could have
didn't
gone
That's
out.
the whole
they could have-
point, it didn't exist.
They had plenty of time to produce an accounting. They could have gone to their vendors. If they didn't have the records, they could have gone to vendors and figured out, well, how much did Delmonico's pay you over the years, right? Get an affidavit, do a deposition, go to the vendors, come up with some methodology, something, anything. But what they did was they effectively ignored this court's order. This court directed them to produce an accounting. Knowing all of this, none of this changed. At the time we were here in front of you last time, it was quite clear. The referee found that they destroyed the point of sale data in the middle of litigation, that they had no records. But this court directed them to produce an accounting. Go back.
Equitable accounting.
An accounting is, by definition, a legal maneuver to demonstrate how monies are spent. They didn't do that. They didn't go to the vendors. They didn't go to any employees to say, hey, this was the pattern in practice. I received my tips paid in cash. We know that the cash was a slush fund. Some of the tips were paid through payroll because they came through the credit cards. Some of the tips were paid out of the safe. Some of the tips maybe were paid out of the $13 million in checks made out to cash. These respondents have put their thumb in the eye of the law for 10 years. This case goes back to 2014. They have had notice for 10 years before this happened that they should clean up their accounting practices. They didn't do it. What they did instead was they froze my clients out, and then they destroyed all the records in the middle of litigation. What is really going on here, and you can read it in the respondent's brief, they say it's absurd to tag these fiduciaries with the liability that the law says that they're responsible for, $70 million. They claim that they admit in their tax returns, they're completely unsupportable tax returns, they admit to receiving $70 million over that 10-year period. None of it's accounted for. They didn't go to the landlord and say, hey, we got this much in rent over the years. Why didn't they do that? Why didn't they even make any effort to sustain it? Because what would have happened is you would have chunked it down.
I have an easy question, counsel. With respect to the cash that was purportedly distributed to employees as tips, as tip money, was there any litigation or any complaint made at any point in time by any employee that the tips that were owed them were not paid?
I'm not aware that there's a matter of record, but the problem, Your Honor.
I mean, it's a lot of money. It's $13 million.
The issue, Your Honor, is not whether the employees were satisfied with their tips, of course, in this case. The issue is what happened to the additional money, okay? The issue is what happens when the employees are tipped out, but there's still millions and millions and millions of dollars being made out, checks made out to cash.
Thank you.
Okay, let's hear from opposing counsel.
Thank you, Your Honor.
Good afternoon, and may it please the court. My name is John Moore, and I represent the respondents in this case. This court should affirm. Supreme Court did not abuse its discretion in accepting the accounting here, proving that respondents did not engage in a theft or fraud. There's been no finding by anybody, including petitioner's own expert, over the years of litigation that any funds have ever been stolen.
I mean, he's saying that you had an obligation under the situation as it was here, that we know that a lot of documents no longer existed, to do more than what you did, to go to vendors and say, well, how much did you actually get paid? To go to employees and say, well, how much did you actually get paid? And that what the expert did, the accountant that testified here, was not at all sufficient. And the judge, should not have accepted that.
No, I mean, that is frankly unsupported as a matter of law. There's no case requiring on an equitable accounting for a party to do essentially a forensic reconstruction of all the books and records over the time at issue.
So what was the methodology that she used that the court could rely on, as it did, so that he completely supported your presentation?
No, I'm glad you asked, because the statement that there was no methodology that was just made up is completely false. And so what the expert here testified to at length is that she referred to the records that were existing, that this court knew existed when it referred the matter for an equitable accounting. Primary among those were the tax returns. Those tax returns indicate all of the income and revenue that was received by Delmonico's, and it also involved the expenses that were going out. If you look at the returns, it starts on page 881 of the record, goes for about 400 pages. So with patience, it shows rent, cost of goods, advertising, salaries. It explains all of those things.
Your adversary argued in his brief, garbage in, garbage out. It was kind of a memorable line.
It is, but it's wrong, Your Honor. And the reason it's wrong is because the tax returns have been repeatedly found through the methodology employed by the expert to be accurate. And so foremost among that, perhaps, is the New York State audit of approximately 3 years worth of tax returns, which the ultimate finding in that audit was an underreporting of 0.25 percentage point. I think it was $46,000 compared to over $18 million in revenue. That is minuscule. That amount from the audited period, those tax returns remain consistent from year to year, going outside of that, so that in terms of both revenue, expenses, the ratio between them, indicating that even the tax returns that were not part of that audit period can also be relied on. Furthermore, there's a period near the end of this period where Delmonico's was in a receivership, and where the special referee and a company hired by the special referee were reviewing the records and were reviewing the business practices and ensuring that that matched what was going in the tax returns. It remained consistent across that entire period. You also have the common size analysis. You have the general consistency across all of those years of tax returns. The fact that it matches the bank statements for Delmonico's for that period.
The analysis.
Exactly, Your Honor. I mean, so you're picking up the points that I missed. I appreciate. But the point is that to say that it is not, that there was no methodology whatsoever, that they were sticking their thumb in the eye of the law, it's memorable lines, but it's just not supported by the law or the facts here. As for the cash analysis, again, there's no requirement, and the court understood that when this was referred back, to pull every single receipt together. Petitioner doesn't even say that is required. Their own expert says it's not required to reproduce every receipt. In their reply brief at footnote 5, they say they acknowledge it's not necessary to show every receipt. You have to put together a methodology, and the methodology here, as Your Honor was indicating, was to look at the tip records, rather, those checks. It matched about 15 to 20% of revenue, which is consistent with being used for tax return, for tips, rather. That tip amount also matched what was reported on the W-2 statements for the employees. No, as Your Honor questioned, and the answer was no. There is no indication that any employee ever thought that they had been underpaid compared to what was listed on their W-2s, which indicates that the money actually was being used for that which it was indicated. It's worth noting once again that this is a restitutionary remedy. That's what the Court of Appeals said in the Ederer decision. To find that there's $70 million, a surcharge of $70 million ought to be employed when there's no evidence of fraud or theft, and when the court correctly exercised its discretion in accepting the analysis that was provided here in the face of nothing presented on the other side, is absurd, and I'll stand by that. Thank you.
Let me address a few things discreetly that counsel said. First, the tax returns. The only finding about the tax returns is the law of the case that the tax returns contain false statements on them. The referee found that, the trial court adopted it, and this court, when it issued its last opinion, also adopted that opinion. The tax returns are inherently unreliable. There is not a single document to connect those tax returns to actual transactions. Whether they made $70 million, $80 million, $90 million, we have no way of knowing. All we can say is they've admitted to receiving $70 million in a very cash-intensive business with parties, everything like that. It is not our burden as the frozen-out shareholders to come forward with the evidence. It is their burden to account as fiduciaries. The sales tax audit was for a 3-year period. It did not show a minuscule underreporting. It showed an 18% underreporting. The penalty that was ultimately compounded by the state was $45,000, but there's no explanation in the record for why that penalty was compounded at $45,000, and it is certainly not a revision of the 18% underreported in sales on the point of sale system that they destroyed rather than turn over to us in the midst of litigation, okay? The referee, the IAS court, this court held that we were entitled to an adverse inference in this case as a result of their destruction of that point of sales data during the middle of litigation. That adverse inference has never been applied, but we are entitled to that. The receivership, the receivership came into effect in February 2020. You know what happened in March 2020? COVID. The restaurant was closed. The receivership was all of a month. The audit here, the accounting order was from 2011 to 2019. She said she didn't look at a single document before 2016. How can you do an accounting for that 5-year period without looking at a single document other than the tax returns, where the only finding here is that the tax returns contain false statements on them? It is inherently incredible. If you own,
Finish your sentence.
if you only look at the court's opinion, the IAS court's opinion, and you do not look at the evidence that supposedly underlines the factual findings that the court made, I will lose this case. If you look at the actual testimony about what the expert did, and you think about the fact that there was no methodology created to verify anything, it's not an accounting.
Thank you.
Thank you, Your Honor.
Vargas versus 622 Third Avenue.
Hello again. Good afternoon, Your Honor. C. Briggs Johnson for JK Flooring. First point I want to make is regarding the contractual indemnity promise in the agreement between Architectural and JK Flooring. 622 Interpublic, JT Magan are not named in that promise. They're not referenced in that promise. There's no incorporation by reference to any other contracts, so we should not owe them contractual indemnity as a matter of law. That's based on, I want to say, 4 or 5 cases from this department: Padron, Talken. I list them in my brief. Second point I want to make is that the indemnity promise also violates the GOL because it doesn't have any savings clause. And secondly, it allows indemnity for architectural and any other purported indemnities if they're found anywhere from 0.1 to 99.9% negligent. So as a matter of law, the GOL should invalidate the indemnity promise. If you're going to get as far as to the indemnity promise between my client and architectural, it's a negligence trigger. It says arising out of the work and has to be caused by an act or omission of negligence of JK Flooring, and there's no evidence that JK Flooring was negligent on this project. The evidence in this case shows that 622 effectively admitted that the water came from the standpipe, that they regularly drained down the standpipe, and that's why the puddle was there. My employee was going to the bathroom because the bathrooms on that floor were dysfunctional.
There was nobody else from JK Flooring there.
No,
They were there.
no. JT Magan told him, "Hey, go here, go use the bathroom."
He was told to report. The plaintiff was told to report to
JT
the
Magan.
GC, to JT Magan.
That's right.
He said they'll tell you how to install the carpet.
Yeah, I'll tell you how to do it.
Wasn't there conflicting testimony about that he wasn't instructed to use that staircase and that he was supposed to use the elevator? So isn't there an issue of fact about it?
Well, I don't know
And
if there's...
if there wasn't any negligence on his part, wouldn't that be imputed to his employer?
That's certainly the law, but the testimony from Interpublic and plaintiffs say that the elevators were in use at the time, and he had to use the bathroom, and there were no bathrooms on the floor. So JT Magan said, "Hey, use the stairwell."
Isn't there contradictory testimony about that? That no one did tell him to use that staircase. They told him he was supposed to use the elevator.
Sure. Okay. So
Isn't that an issue of fact?
I don't think on negligence though, because there's a giant puddle, right?
But if you disregard the instructions to use a different way and you decide to go your own way,
I see your
an
point.
elevator that says no entry, then doesn't that raise an issue of fact?
I don't think so because he's opening a door to use the bathroom. That's not
He's going in a
negligence.
he's on a floor. Everyone's using the elevators. If it's true that he was told to use the elevators and he just decided to use this stairway that said no entry, and that's where it happened, why, if that was all true and that was all proven, why wouldn't that be some evidence of his own negligence?
Well, in my opinion, Your Honor, and I think it would be a kind of a big stretch of negligence principles for him to put negligence on plaintiff for disobeying an order just to go to another floor to use a bathroom when it's basically uncontroverted that the negligence in this case is the puddle. So if you're going to say as an issue of fact that he decided to open a door even though he wasn't supposed to use it, I don't think that's negligence. I think maybe it's not, maybe he shouldn't have done that. Maybe he should have waited for the elevator. But I think the negligence is the puddle, right? So And if there's not any other questions, I'll rest on the rest of the arguments in my brief.
Thank you.
Thank you.
Excuse me. Good afternoon, judges. My name is Janet Ford. I represent J.T. Megan, the general contractor who was retained by McCann Erickson to do an office renovation project at 622 3rd Avenue. McCann Erickson was the tenant. J.T. Megan contracted with McCann Erickson and had no authority, no control. In fact, was by contract was explicitly prohibited from entering the fire stairwell.
Doesn't that go to the same issue of fact I raised with the other counsel about who instructed him to use that stairway? And if your employee did instruct him to use that stairway to go to the bathroom, isn't that, at least on some level, exercising control over the way he performed his duties? And if that is true, wouldn't that at least raise an issue of fact as to whether your client was in some way responsible for this injury occurring?
Well, you know, getting away from the issue of fact here, first of all, let's be clear. Our superintendent was clear. He did not direct anyone to use that fire stairwell.
Right, but plaintiff says he did.
Well,
why isn't that an issue? Again, just so it was an issue of fact for them, why is it an issue of fact for you?
well, let's go to the law. J.T. Megan had no duty to plaintiff. Not only were they explicitly excluded.
Let's say he had no duty. The law is that if you exercise some control over the activity, then that is a basis for imposing liability. So don't we have to look at whether they did in some way exercise control over the plaintiff's activity. And if they specifically said to the plaintiff, hey, use this stairway to go to the bathroom, isn't that an issue of fact as to whether they in fact exercise control, which would in effect create a duty?
The argument here by law is that J.T. Megan had no control over that stairwell and had no duty to the plaintiff, who J.T. Megan, you have to realize, was also excluded from covering any of the floor work on the floor where plaintiff was working. So those were two things that happened. So there was no duty to plaintiff by J.T. Megan. And in fact, the Supreme Court got it right when they said that J.T. Megan was not a statutory defendant, period, because, and I quote, plaintiff's accident arose from a leak that existed.
We're talking about 200 in common law negligence. We're not talking about 240 or 241-6.
Your Honor, how is J.T. Megan responsible under Section 200 when the court found that they weren't even statutory defendants under the labor law?
Wasn't your project super responsible for site safety on a day-to-day basis at this location?
Not in the fire stairwell, no. They had no control over it. They had no duty to inspect, and no one was supposed to go there.
No one said he's supposed to that he was supposed to inspect, but he was the site safety supervisor for the whole project. And there's at least testimony out there that when the plaintiff came in, there was nobody else from that flooring company there. So he was told to go to Mr. Tadali, your employee, to be told, what to do and how to do it. And or at least he says, I mean, this is in the record, that your person said to him, if you need to use the bathrooms, they're upstairs or downstairs, whatever, you may have to use the stairs if the elevators are empty. Now, you may say something different, but aren't those issues of fact that we have to consider at this time?
Yeah, Your Honor, the stairwell was not part of the project, and that's key. And also, J.T. Megan did not retain any of the flooring contractors, and that was both were totally out of their purview. Now,
was there some evidence that your client was aware of the leak? Actually, aware of the leak?
Well, again, our superintendent totally denied that, and neither was it their duty to inspect or remedy or have any control over the leak. The building was responsible for inspecting the stairwell to make sure it was safe.
Did he say, I can't believe, what is this, there was water leaking from the I can't believe that these guys haven't fixed the standpipe.
That's what
I told them to address this issue already.
That's what plaintiff said, Your Honor, yes. But that's, even if that's true, and our person totally denied ever saying that. But even if it
So I
was
go back to
true,
what my colleague said at the outset. If there's a controversy as to whether or not that was said and whether or not there was constructive notice, then don't we have an issue of fact?
where J.T. Macon had no duty, it doesn't even matter if they knew of any kind of leak or not. And what control did our superintendent have over a plaintiff who chose, despite signs on the door, to enter a prohibited area just to get quickly to there?
Thank you.
Okay.
Good afternoon, Your Honors. May it please the court. Daniel Wright, I'm an attorney from Milburn Mackers, Posadas and Sidon, on behalf of the third-party defendant, respondent, appellant, Architectural Flooring Resources. I'll refer to them as architectural, as the co-defendants did. To keep this brief, the narrow issue of our appeal is separate from what the co-defendants just argued. It's actually unopposed, the narrow issue of our appeal. AFR, as the court is aware, was the flooring material supplier. We moved for summary judgment in the lower court. The lower court found that we were free of negligence. They used those exact terms in their decision. They granted a summary judgment dismissing the third-party complaint against AFR.
You're saying it was just a mistake not to let you go completely.
Thank you. To cut
just
to
didn't
the
parse
end,
it
to cut the spark notes of it is that we believe it was a simple mistake, a scrivener's error. Even if it wasn't, none of the parties here are alleging that we were negligent in their papers.
And the
on
court
appeal.
found you were free from negligence below.
Correct, Your Honor. If there's no further questions on that issue, I'll rest on the papers. Thank you.
I'm getting confused about the parties here now. Whether do you have 2 minutes? Not you. Do you have 2 minutes?
Good afternoon, Your Honor. Stephen Lane for Jason Vargas, the plaintiff respondent. Again, the only issue that the plaintiff has in this case is that we feel that the lower court got it right with the issue of Labor Law 200 and common law negligence. There's clearly multiple issues of fact, as your honors have all pointed out. And the fact that, as Ms. Ford keeps harping on, that the stairs weren't part of the construction site is just not true.
Well, they were doing work in they were doing some work in the stairway also as part of this big project. Weren't they replacing some of those sprinkler systems?
And in order to do so, you had to agitate the, that's their term, the valves and the standpipe, which J.T. Megan would ask the owner to do. The owner was at their request doing this work.
They were turning them on, putting so that it wouldn't be leaking, fixing them up. So it was, there was stuff going on with those pipes.
Correct. And again, taking plaintiff's testimony as true as you would for the opposition of the motion. He was told he could use the elevator. He was told he could use the stairs. The gentleman complained, Mr. Tadaldi, I knew there was water here. Why didn't they clean it up? There's multiple issues of fact. The Supreme Court clearly got it right. Unless there's any questions, that's all I have.
Thank you.
Good afternoon, Your Honors. May it please the court, Irina Kravchenko. I represent Interpublic respondent vis-a-vis J.T. Megan. It is Interpublic's contention that the Supreme Court also correctly denied J.T. Megan's motion to dismiss all the claims, most specifically contractual indemnification claims asserted by Interpublic against it. The indemnity provision trigger is arising out of J.T. Megan's work and caused by its either negligence or breach of contract. As the panel pointed out, this general contractor had safety obligations, perhaps even instructed plaintiff to take that route. The superintendent testified specifically that his job was to facilitate bathroom usage. All of these questions, all of this testimony raises tribal questions of fact as to whether J.T. Megan was negligent and breached its obligation under the contract to keep everybody safe, including employees that are not hired by their subs, and to follow the rules of the owner, which is not to use the stairways. Therefore, this court should affirm, and I'll rest in my brief.
Thank you.
Thank you.
I think you go next, but it doesn't really matter. Are you waiving your 1 minute rebuttal?
What'd you say? Oh, I have a minute?
Don't want to miss that.
You each have a minute. You each have a minute. I gave you one, though.
I'll take 48 seconds, okay?
Okay, I'm timing you, 48.
Yes, so regarding, just in case the court didn't accept point one of my brief regarding the owner and JT Magan not being named in the indemnity promise, their negligence is all over this project. 622 created the condition, and JT Magan was touching the sprinklers. That was part of the renovation project. So you can stay, we're not working in the stairwell, but you also had to do the sprinklers. And what are the sprinklers related to? The standpipe. They facilitated, they encouraged the drain down. They helped create the dangerous condition. Thank you.
Judges, there are three very important misrepresentations here that please let me allow them to correct. First of all, no, there was no work being done in the fire stairwell, period. The way this works, if there's hot work to be done on the project site that JT Magan was having control over, you have to turn off the sprinklers and you have to drain them. Because if you don't, the hot work, welding or whatever is being done will turn on the sprinklers, everything will get flooded. So to do that, someone from JT Magan says, we're going to do hot work on this day, and then someone from the building and McCann do all kinds of approvals, and they drain the pipes, and they turn off the sprinkler system so that it won't be inadvertently turned off. And then when the contractors are done with their hot work, the building then replenishes. So that's what happened. JT Magan had to say that they controlled the sprinkler system or did any work on the sprinkler system. It's a but for. Okay.
Thank you.
There are two other errors.
Thank you.
Okay.
Okay. People versus Dominguez.
May it please the court. Wang Jiri for defendant Jose Dominguez. There was only one live issue at trial. Who was the shooter? Defense was precluded from presenting evidence that showed the victim had identified another man, Elmer Confessi, was the real shooter. In fact, defense counsel opened on the Confessi identification, relying on a pretrial agreement between the parties. Defense counsel, however, was sandbagged in the middle of trial when the prosecution reneged on that agreement and decided to oppose the introduction of the evidence. The trial court erred in agreeing with the prosecution and excluding this critical exculpatory evidence. And if time allows, Your Honors, I would also like to talk about the 10 highly prejudicial arrests.
Counsel, you arguing that the exculpatory evidence was reliable? The victim was intubated, I believe.
Sorry,
And
can you repeat
He
the
was intubated?
Yes, you're right, Your Honor.
And he was also drugged, right? He was medicated?
That's right, Your Honor.
As with fentanyl?
That's right, Your Honor. There's numerous indications of reliability, and I'm happy to go through all of them. But to address your specific point, there's no indication in the record that the fentanyl rendered the declarant unreliable. In fact, there's a clear record where the declarant had an exchange with the detective who was questioning him, and in fact, I correctly identified Mr. Garcia as one of the people who punched him, and he also correctly identified Mr. Confessi, or rather, he correctly answered the question that Mr. Confessi was the person who shot him, and then turned to his mother to clarify that that's him, but he has longer hair now. Now, the reason he said that was because the picture that the detective showed him of Mr. Confessi showed him with short hair. And of course, the shooter in the video had long hair. So this exchange, I think, makes it very, very clear that Mr. Martinez, the declarant, was conscious, lucid, and was fully aware of the exchange.
Did he also say to his mother that the shooter had been Ori, meaning the defendant?
Yeah, Your Honor.
That was the nickname of the defendant, correct?
Your Honor, that's right. However, Bori happens to be a very common nickname for Puerto Ricans. And in fact,
Well, how many Puerto Ricans were known in that area as Bori?
Well, for starters, Mr. Garcia's nickname was also Bori, and this is clear in the record. And I think there isn't necessarily a contradiction here because the question itself was ambiguous. The question that the mother asked him was, who did this to you? And he said, Bori, Bori, Bori.
Right.
That could have been consistent with him identifying Mr. Garcia, who was one of Mr. Martinez's attackers. And that's also consistent with the later exchange with Detective Colon, where Detective Colon asked him first, who is this the person who punched you, and showed him a picture of Mr. Garcia, and Mr. Martinez said yes. So all of that is very consistent.
Did the judge disallow both statements, both sets of identifications?
That's right, Your Honor. The judge did exclude both statements. However, the confessee identification is different here because it has constitutional dimensions. This is a defendant has a constitutional right to present reliable statements if it's critical to his defense. And the confessee identification met all of those standards here. And therefore, yes, the Bori statement was excluded, but the distinction here is that the confessee identification had implicated constitutional rights of Mr. Dominguez, and therefore it should have been admitted.
Despite the fact that Mr. Blanco, who was the testifying witness, stated that Mr. Cofresi, that was the person, he wasn't there, and that the detective investigated, brought in this particular individual into the precinct, questioned him. This person said, I was somewhere else at the time, and it was confirmed that he had been somewhere else at the time of the shooting.
Your Honor, let me take that one by one. First of all, Mr. Blanco was an unreliable witness for many reasons, but to specifically address your point, Mr. Blanco was an unreliable witness, and to specifically address your point, Mr. Blanco actually refused to sign a picture of Mr. Confresi, saying that this person was not involved in the shooting. So that's hardly
Well, that's not what he testified to. He said, I'm not going to sign it because he was not involved in the shooting. He was there. He was there with the victim when they were approached by three individuals, one being the defendant, and he saw the exchange. He saw that they argued, and then he saw that there was some type of a scuffle, and then he ran, and then the victim also ran in the same direction that Mr. Blanco was running.
Your Honor, Mr. Blanco did testify to what you said. However, Mr. Blanco was unreliable because he refused to sign. I mean, if that's truly what he believed, there was no reason for him to not have signed a picture of Mr. Confresi, saying this person was not involved in the murder. So he refused to do that, even though, according to him, Mr. Dominguez was the shooter, refused to sign someone else saying this person was not involved. And Mr. Blanco was...
We have some time on rebuttal.
Yes, thank you.
Good, I guess, evening now, Your Honors. May it please the court, Noah J. Sexton for the people. If the court will indulge me, I just want to clarify something up front. I'm pretty emphatic about this in my brief. This was not a sandbagging by the people. This was an agreement between the assigned prosecutor, retired ADA Rosenfeld, and defense counsel that we will let you elicit testimony about this purported Confresi identification, and in exchange, we will be able to elicit testimony about the Bori identification. At the last possible minute, defense counsel comes forward and says, actually, we don't want this admitted because he's intubated, he's on fentanyl, it's unreliable. And as ADA Rosenfeld said to the court on the record outside of the presence of the jury, okay, well then you can't have it both ways. If he was unreliable because of fentanyl and intubation with this identification, what changed it with the other identification? Now, I'm not denying, we don't deny in our brief that he has the right to present a defense, and under Ohio v. Roberts, if there's sufficient indicia of reliability, he can, bring up this identification. The problem is that there is no real indicia of reliability here. As they pointed out in the court below, he was under the influence of fentanyl, he was intubated, he was paralyzed from the neck down, and a couple of hours later, or a day later, he proceeds to identify Bori, contradicting himself completely. And it states emphatically, Bori, 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 to the extent that defense is now arguing, oh, that could have been anybody, that's supposition, especially considering the fact that he and Hansel Blanco knew this defendant, knew him as Bori. There's just nothing in the record that indicates that he was referring to anybody else. I would also quickly turn to the issue of Hansel Blanco's testimony. Hansel Blanco was a credible witness, A, the jury credited his testimony, and that is worthy of great deference. B, the only two arguments that they make about the reliability or the credibility of Blanco as a witness is that he had admitted that he had smoked a little marijuana and consumed a little promethazine cough syrup they call lean prior to this happening. But he also testified that it didn't really impact his ability to walk, talk, see. He's right next to his best friend, going to the Chinese food restaurant. Everything he said in his testimony was consistent. It did not stray. He was subject to a diligent cross-examination as well as a thorough direct examination. And at no point did he stray from what he said happened. Their second argument, that he refused to sign this image of Confresi, that is again supposition. Oh, well, if it was not him, why wouldn't he sign it? Great question, not in the record. And he also stated that it's because he had nothing to do with the death of his friend. I will also just quickly turn to the fact that, to the photographs, because I believe that's what my adversary wants to bring up on rebuttal. These photographs did speak to a critical fact we were trying to establish, which is that this defendant, A, changed his appearance from the time of the crime to the time he was sitting in front of the jury, and B, that he had a history of changing his appearance very radically. This was not a matter of, oh, well, he just got a little haircut and glasses. This is a matter of he looks like completely different people over a relatively short period of time. These photos were sanitized. There was a jury instruction that was given to not speculate as to the origin of these photos. And unless they can establish that there is some reason to think that the jurors didn't follow and understand this instruction, there should be a presumption that they did understand and follow it. And above all else, this defendant was found guilty beyond a reasonable doubt of the murder of Martinez. In this situation, we have not only the CCTV footage, which matches Hansel Blanco's account of what happened that day, we also have the DNA evidence, which shows that the primary donor of DNA on the handle of the gun was donor A, eventually matched to this defendant, had a genetic pattern that is only shared 1 out of 6.8 trillion people. For reference, only about 100 million or 100 billion people have ever existed on the face of the earth. That's just about as clear as you can get. And we've got Hansel Blanco's honestly, emotionally painful, detailed testimony that in and of itself could have sustained this conviction. But instead, we brought forward a strong case, proving it on multiple fronts, and there is no reason to discredit what Blanco said or to disturb this conviction on appeal. Thank you.
Thank you.
Your Honor, a couple of quick points. First of all, there were numerous indicia of reliability. First of all, there's corroborating evidence. The shooter in the video closely resembled Mr. Confresi, and in fact, so much so that Detective Colon, the investigating detective, went after Mr. Confresi, not Mr. Dominguez, after studying the video closely. And Mr. Confresi was also not a stranger to either the neighborhood or the people involved. He lived only 3 blocks, I believe, away from the scene of the shooting.
The problem you have is that the only person that we see in the video running after the victim, we see also in another video pacing up and down is the person that Mr. Blanco says is Body.
Your Honor, Mr. Blanco was high on drugs. He was high on codeine. He was drunk. He was also an unreliable witness. Period. He said he saw Mr. Dominguez shoot Mr. Martinez. However, it's clear that he ran into the other direction. He never saw the shooting, so he didn't have personalized knowledge. He also refused to sign. If he was so confident, then why didn't he sign the picture of Mr. Confresi saying this was not the man who was involved? So for all of those reasons, Mr. Blanco was not a credible witness here.
Thank you, and thank you very much for your service in this matter.
Thank you, Your Honor.
Appreciate it.